Open a public hearing on House Bill 3284. I'm sorry. Oh, yeah, okay, yeah, 3284.
Mr. Chair, members of the committee, House Bill 3284 eliminates the statute of limitations for certain crimes committed against minors. Crimes are rape 1, sodomy 1, unlawful sexual penetration in the first degree, sex abuse 1, incest. Lengthens statutory time of prosecution for strangulation, criminal mistreatment 1, rape 2 and 3, sodomy 2 and 3, unlawful sexual penetration 2, sexual abuse 2, using a child in display of sexual conduct, encouraging child sex abuse in the first degree, promoting prostitution, compelling prostitution, and luring a minor. Act declares an emergency effective upon passage.
Call Carla Benson, Dr. Kerry Ecox, and Eric Hassel.
Mr. Chair,
Yes.
just while they're coming up, as you can look out and see a good chunk of the room having those stickers, yes, on 3284. I just want to acknowledge probably about twice as many are in the overflow room here, even though just because you aren't in there or in here doesn't mean we don't know you're there, and we appreciate your coming down to the Capitol today. Thank you, Mr. Chair.
Thank you. Please go ahead in any order, but remember to identify yourself for the record.
Okay. I'm Carla Benson, and I am personally a survivor of child sex abuse. Childhood should be about smiling, laughing, playing, imagination, innocence, being carefree, and of course, feeling safe. For many children, that's not the case, and unfortunately, I happen to be one of those children. My innocence was taken from me by a stepdad who felt his pleasure was far more important than me being a little girl. At the age of 7 and again at the age of 8, he took what was not his to take, all threatening that he would hurt me again if I ever told anyone. Because it had happened at such an early age, I just assumed that this is what happened in everyone's home. So I didn't tell anyone until I learned in 5th grade that this was not only abnormal, it was wrong. So at age 10, I came out for the first time to my mother and told her what had been happening to me the last several years. Nothing happened. In fact, a few weeks later, I was sexually abused by a family friend while I was spending the night with her daughters. In 8th grade, I tried to speak out again. I had sent or passed a letter in class at the end of 7th grade about what was going on. The teacher took that note, put it in her desk, and it wasn't until 8th grade that I heard about this note again. When I was called to the vice principal's office, I was met there by a police officer who happened to be my sister's best friend's dad and a social worker. I felt like I was in a bit of a quandary as far as the police officer, because I knew that if I spoke up about what was in my letter, my sister risked losing her best friend. The social worker asked me questions using words that were very adult, and I had no idea what they meant, and she asked for details of what had happened to me. And because it had happened so many years before, I didn't remember all the details. Her words, "Carla, if it really happened to you, you must remember," rung through my ears and my being for many, many years. And I paused for a very, very long part of my childhood, wondering if maybe I had just made up everything. I returned to the abusive home again, but again, I was thinking about the words of the social worker, if maybe I just made this whole thing up. It was not until I was 20 years old and away from my abusive environment completely that I was strong enough to stand up to him and come forward. And I had learned that there was a thing called the statute of limitations, and I was still within the statute of limitations. My family was not brave enough to stand with me, and I did not feel strong enough to do this on my own, so I again abandoned this going forward and pressing charges. After many years of counseling and realizing that I was, in fact, strong enough to do this on my own, I was met with the words, "Sorry, the statute of limitations has already passed." I'm sure you can imagine, after all of those years of even being brave enough to come out and admit that it was even happening to me, the fact that I was possibly going to lose any family support and expose my entire family was very scary, and I did not want to hear the words that, "I'm sorry, the statute of limitations is over." No victim of abuse should ever hear these words. It takes a long time to admit it, and like I said, a long time to get brave enough to stand up to your abuser. When my day did finally come, my abuser should have been made accountable for his actions. Instead, he walked away, and I have had to deal with counseling and dealing with what he did to me as a child. Please join the other 33 states who have already taken this statute of limitations away and support the abuser, or support the survivors, not the abuser. Thank you.
Thank you.
Chairman Barker, members of the committee, thank you for allowing me to speak today. My name is Carrie Hecox, and I am the medical director of the Children's Advocacy Center of Jackson County, a position I have held for the last 5 years. In my role at the Advocacy Center, my job is to be the examining physician on children who are suspected of having been abused or neglected. And in that role, I have seen well over 1,000 children, roughly 70% of them who there were concerns that they were victims of sexual abuse. I'd like to talk to you about two things that I think is important for House Bill 3284. The first one, and I will speak both from my personal experience and from what we know from the literature, I think the most important thing to know about child sexual abuse is that it's extremely rare for children to disclose abuse in a short time frame after it happens. Most of the children that I see weeks to months to even years after they have been abused. And if we look at the literature, there's been some good adult retrospective studies. This is questioning young adults about if they had been abused as children and if they ever told anyone that they had been abused. In those studies, what we've found is 70% of young adults who say that they were abused as children never disclosed that abuse in childhood. So the vast majority of children who are being sexually abused are not disclosing during childhood. And there are several reasons for this. I think it's important to note, unlike many other crimes, child sexual abuse is a crime that occurs within families. So children who are being abused are often dependent on their abuser for many different reasons, for financial reasons, food and shelter, and then emotionally dependent. If you look at when child sexual abuse occurs, it's occurring in the developmental period of a child. So I think what was mentioned earlier, children don't necessarily know that it's wrong, or they have some idea that it's wrong, or there's something about this special relationship that makes it okay just this time. So what we have is children who are groomed to believe what is going on is okay, and it takes a very long time for that process to resolve itself for a child to come forward, and indeed many children never come forward to disclose their abuse. I'd also like to talk about something that I see in my own practice regarding intergenerational abuse, which I think has an impact on considerations of the statute of limitations. We know from studies of sexual abuse offenders or pedophiles that it is very rare for you to have a pedophile with a single victim. So it has been my experience where I have seen children who have disclosed sexual abuse by an older family member, say a grandfather, a step-grandfather, and in the process of investigating that, what we find out is that there were suspicions that an aunt had been abused, or that an older family member who had never disclosed during childhood had also been abused. I think resolving the statute of limitations has a lot of impact, not only in holding the perpetrator accountable for what they did to older family members, but also in supporting younger children who are coming forward. If there are more people there to support them, to say, this happened to me too, I support you with what you're doing, that gives a lot of added support to the child, which is very important. The process of criminal prosecution of child sexual abuse cases is frightening for children. It's a very difficult process for them to go through. So having more support is significantly important.
Thank you.
Questions?
Thank you, Chair Barker, members of the committee. My name is Eric Hasselman. I'm a senior prosecutor with the Lane County District Attorney's Office. I'm in the Major Crimes Division of that office. I've been in that capacity for 10 years, 18 years in my career as a whole. I appreciate the opportunity to speak to the committee this afternoon about House Bill 3284 and the support that I have for this bill. In the last 10 years of my career, the lion's share of my caseload has revolved around the abuse of children, from minor physical abuse cases all the way up to and including aggravated murder. In the middle of that, short of the child's death, there are a lot of other heinous things that happen to children, particularly in the sexual abuse arena, that I've had the good fortune, or the privilege, I should say, to go to bat for these victims in court. House Bill 3284 proposes to eliminate the statute of limitations for sexual abuse, serious sexual abuse of young children, children under the age of 14, with the exception of incest, which is up to 16 years of age, but there's a blood or family relationship. This is an arbitrary limitation, like all statutes of limitation are. It's a bright line that a prior legislature has established, after which a case is dead, an investigation is dead, no possible redress for victims of this type of criminal behavior can occur. Currently, through my career, I've seen several changes that this legislature has made to the statute that have allowed me to actually prosecute and take action against offenders who in the past I would not have been able to do. And I commend the legislature for doing that, because in each and every one of those cases, those have been extremely important to the victims who, again, I've been able to represent their interest in seeking justice in court. Currently, if somebody is able to disclose that abuse up to the age of 29, we can still take action. But if they wait until they're 30, we can't. I would suggest there's no justification for that line. There's no justification for the legislature to establish a limit at that point by which we have to tell 30-year-olds, 31-year-olds, 32-year-olds, 50-year-olds that, I'm sorry, ma'am, I'm sorry, sir, we cannot seek redress. We cannot seek justice for you in the court system against this offender. This type of limitation ignores common sense about sexual abuse in children. And I appreciate the comments of Dr. Hecox and Ms. Benson regarding some of the motivations behind that. Dr. Hecox's references to the literature right now seem to be mirrored by the FBI statistics. The last time I was privy to those statistics, the FBI indicated that it was 1 in 20 that disclose their sexual abuse as children. I don't expect that a change in this legislation is going to significantly change the degree or number of reports that we get. The fact of the matter is, this is still very personal to some people. They still have internal motivations never to come forward. But where it can help is in the people that do have the courage, through whatever means they've arrived at that, to come forward and report their abuse. Late disclosures come up on occasion through my practice. I see it when I'm interviewing prospective jurors. There's times in my career where, in picking juries for a child sexual abuse case, I've had somebody in their 50s or 60s indicate that, yes, they themselves were a victim of sexual abuse, and the first person that they'd ever disclosed to was me in that proceeding, because the judge had required them to tell the truth. That, I think, captures the reality of this type of crime. It's not like robbery. It's not like theft. It's not like physical assault, where people have a motivation to report immediately. There are barriers sometimes, families that determine that the child should not go forward to the police, and they try to bury it, they try to handle it within the family. We've found that that's not effective. This legislature's recognized that over the years, and in fact has made changes even to the expungement statutes, recognizing that there are some crimes, like sexual abuse crimes, that should never go off somebody's record, because people who abuse children sexually don't change that behavior. It's only through intervention that we're able to make a difference in that. I understand the opposition to this bill includes the fact that it will be harder for defendants, the accused, to defend themselves. I would remind this committee that that applies equally in our justice system to the state. Even with people coming forward, perhaps people like Ms. Benson, years later telling us about this, we may not be able to prosecute because there's nothing about this bill that changes the burden of proof. The burden of proof still remains with the state to prove these allegations beyond a reasonable doubt. And I will tell you that time is the enemy of prosecutions as well. Memories fading is the enemy of prosecutions as well. It's very difficult for us to proceed on old cases, but not impossible. As I was leaving the courthouse in Lane County this morning, I ran into the detective sergeant from the Lane County Sheriff's Office and told him what I would be doing this afternoon. And he applauded me for my efforts, saying in the last couple of years he's had 2 investigations he could think of that they were not able to accomplish justice. They were not able to seek justice on behalf of victims on cases that were very strong on their facts. There were witnesses within the family that even the suspect had admitted the behavior to, and they could take no action because of this arbitrary line. That's unacceptable. Oregon finds itself right now in the distinct minority of states that are protecting sexual offenders of children. Another potential criticism for this bill was that, you know, it could resurrect the sins of youth sometime down the line when so many years have gone by, but that's not simply the case. A review of the language of this bill confines it to adult offenders who offended against children. They had to have at least been 18 years old for this statute of limitations extension to apply. And for those who've already passed, those offenders who've already had the good fortune of the current statute of limitations in place, sunsetting their case, their ability to be prosecuted, it can never be resurrected because of the ex post facto protections of this type of criminal procedure. So, as I indicated, the legislature has made strides over the last 2 decades to continue to increase and recognize this hybrid type of case, the fact that the motivations behind these kind of cases are so much different than other arenas of criminal activity. And it's my respectful suggestion to this committee and the legislature as a whole that it's time that Oregon join the ranks of the majority of states in our country and eliminate a statute of limitations regarding the most serious of child sex offenses.
Thank you, Zinni. Representative Garrett.
Thank you. I think you said this at the beginning, but just remind us what the current statute is, how it works.
Well, it's 12 years from the time that the child reports to either the Department of Human Services or law enforcement. However, if the child never reports, that clock starts ticking when the child turns 18 years of age. And so effectively, they have a victim of or survivor of child sexual abuse or assault has until 30 years of age to
30
report.
years or 12 years, whichever is earlier.
Whichever comes first.
Right.
That's correct. And that, again, the 30-year birthday, right now, the offender's scot-free from the ability of the state to prosecute.
Thank you, Mr. Chair. I'm wondering why the crimes included stop at 14 and 16 for rape, sodomy, sexual penetration, and sex abuse at 14, and 16 for incest, and why it's not until they're 18 if they're still considered minors.
I can't answer that, not being the sponsor of this bill. However, I would suggest, at least in my practice, that the potential fiscal impact of those prosecutions would be significantly greater than the ones that are proposed.
Thank you.
Thank you. I want to thank especially the victims who showed up today for the terrible hand you've been dealt, and really appreciate you coming down here and being able to stand up and say that. I appreciate, Doctor, that working with these victims is crucial for their survival. I really want to thank you and the prosecution. I know in your business you're paying with your soul to prosecute these cases, to go through them, and I think I speak for the committee and probably most citizens of Oregon. Thank you very much for all you've done and all you're doing.
Thank you, Chair, and thank you,
you.
committee.
Christine Ruck, Diane Billens again, and Darrell Fuller. Just identify yourself.
Yes, good afternoon. Chair Barker, thank you for the opportunity to be here today, members of the committee. My name is Christine Ruck. I'm from Lynn County, a resident of Lebanon, and I'm here today not as a part of any group, but as a grandmother who has watched the multi-generational effects of child abuse and the difficulties that you face when you walk up against that statute of limitations. In my particular case, there was a niece, this is not in the state of Oregon, but in another state, and she just barely reported under the statute of limitations. And it was over 3 years before there was a conviction, and it was only an accidental confession by the abuser that incarcerated that individual for 15 years. But during that process, we discovered that my youngest stepdaughter was his very first victim. She is now nearly 40 years old and still cannot admit to anyone else what has really happened to her. It has become something that she's internalized. It has made it very difficult for her to parent effectively, and her children now are unfortunately suffering the effects of that initial abuse. The lack of treatment for the victims is costing us so much, and I don't know that anybody's economic model or projection can really quantify that cost. When I look at this bill, the first thing I wanted to do was come up here and tell everybody that was sitting in front of me that if you didn't vote for this, I'd find a way to make sure you were never reelected. That was my gut feel. But then it occurred to me, why is it that we haven't done this before? It just seems so simple to give the victims what they've really needed a long time, because this is a key to healing, to knowing that somebody is going to say, yes, you were abused, and yes, I'm going to do something about it. There are difficulties in prosecution, and nobody's ever going to deny that. It's like putting together a giant puzzle, but the multiple victim factor means that we have to start with the first piece, wherever that comes from, whenever it shows up. And as that first piece shows up, we start adding the rest of those pieces. And in discussing this with district attorneys and other representatives, former law enforcement officers, during the cases I've been involved in, sometimes they aren't always aware of the rest of the victims. And so perhaps, and it's not in this bill, maybe there's a way to come up with some kind of a victim report system that will help law enforcement put together all these various pieces that occurred decades apart and great distances apart, maybe even states. It's a bigger problem than we can address here today, by far. But one of the things that caused me to come forward today was to make sure that any yes vote on this measure is followed up by supporting victims in the rest of the changes in criminal statutes and sentencing that are going to follow. It makes no sense to me to open up the statute of limitations for one group of victims only to find out that once we've successfully prosecuted someone else's abused, that their sentence is reduced and they're returned to offend again, to find more victims. Those two things seem, in my mind, very, very much in opposition to one another. So I hope that any yes votes that result in favor of this bill are a true commitment to the victims to follow that all the way through and make sure that accountability is solid and that this is not just one place to say yes and then find an excuse to say, well, I just couldn't get there on that other bill. That would be the hardest thing for me to swallow, because no victim should have a hollow victory at the end of this session, thinking they got a victory in one hand and a failure in the other. So please, if you're going to vote yes, make sure that's universally in support of the victims.
Thank you.
Thank you.
Chair Barker, members of the committee, my name is Dinah Vittelens, and I'm the Crook County District Attorney. I would like to let you know that as far as House Bill 3284 goes, the Oregon District Attorneys Association could not unanimously say in favor or against, and I'm sure you're all shocked knowing the district attorneys that we couldn't agree on something. But when we don't do that, we take no position, yet individual district attorneys are encouraged to come to say either for for or against. And I can tell you that the arguments against House Bill 3284 was that that it would give a false sense of hope to victims. And I can tell you, prior to thinking about it hard over the weekend, I was inclined to think that this was a way to give false sense of hope to victims. And then when I thought about a victim actually coming forward and disclosing abuse, and then I get to, as an elected official, give a pat answer of, oops, sorry, it's against the statute of limitations is run, is not for me to do. I have a duty to investigate and consider, and if this victim is willing to come forward, then I should have to give a close look at the case. And so that's why, as Crook County District Attorney, I'm fully in support of 3284. Thank you.
Mr. Chair, members of the committee, Darrell Fuller on behalf of the Oregon State Sheriff's Association. I've had the privilege of being a part of this process for about 25 years now, and I know from experience it's the responsibility of the proponents of a bill to build the case and build the coalition to convince you to make a change to the existing law. But I'm hoping today to turn that on its head a little bit and ask you to do just the opposite and see if there is a case that can be made, if there's evidence out there or a coalition that can convince you to keep the statute the way it is. Why would we want, and I wasn't around, I don't think, when the statute of limitations was created, I don't know how long ago it was, but why would we want to create a statute to protect people that are sex offenders from prosecution just because they were able to hide it long enough? And if you can make a case for that, you should be a lobbyist because you have great, great communication skills. Be happy to answer any questions you have.
Thank you. Thank you, panel. Gail Meyer, Becky Strauss.
Thank you, Chair Barker, members of the committee. Gail Meyer on behalf of the Criminal Defense Lawyers Association. I was asked to not take a lengthy time in my comments, and so I will truncate them. The statute of limitations is not a mere technicality. It really does underscore and serve and make concrete key foundational principles in our system of justice, which happens to be the best in the world. And those include procedural due process rights, such as a speedy trial, the right to call witnesses, the right to compulsory process, meaning to subpoena evidence and people to the courtroom, the right to present a defense, the very right to the presumption of innocence, and the right to a fair trial itself. There was a comment made that there is no justification for not eliminating the statute of limitations, and I would suggest otherwise. Because with delay, you call into question the ability to serve any of those constitutional principles. Witnesses, and I'm not talking about the accuser, and I'm not talking about the accused. I'm talking about witnesses who might corroborate or who might refute the allegation. They die, they move away, their memory fades, their memory might be influenced by hostility or suggestion or life experience or after occurring events. Similarly, documents which can corroborate or refute an allegation get destroyed, they get mislaid, and they disappear. So with the passage of time, it's inevitable that our trials devolve into one of one witness against another, which calls into questions the discovery, pretrial discovery rights of the accused in Oregon. And I'm passing out to you, I do have written testimony, I do have a chart that I've submitted online that compares the discovery rights in a criminal case to the discovery rights in a civil case. But what I want to do with this chart is just highlight for the committee how the discovery rights in Oregon are so much less than they are in other neighboring states. So, for one thing, Oregon is the only state in the union that tolerates a 10-2 jury verdict in a criminal case. Allows 11-1. All other 48 states are unanimous. The federal system is unanimous. The federal territories are unanimous. So in Oregon, you can have two jurors pounding the table saying, I am not convinced beyond a reasonable doubt that the state's made its case. I vote not guilty. And in Oregon, That means something different in Oregon than it does everywhere else in this nation, because we are the only state that will take that person, put them on a bus, and send them to prison on mandatory minimum Measure 11 sentences with no sentencing discretion. But we are the only state in the union where that would constitute a verdict of guilt. You would like to think, backing up from there, that Oregon would have enhanced discovery rights for the accused, since we do tolerate such reasonable doubt in our jury rooms. And in fact, we do not. So on the left column, you'll see that all the other 13 Western states require that the grand jury get recorded. In almost all those instances, the accused is given copies of those sworn grand jury transcripts, statements. That does not happen in our state. So we have fewer discovery rights on top of a 10-2 jury verdict, and I would submit that because we have a 10-2 jury verdict, it's very, very important that this body and everyone in Oregon pay attention to the procedural due process protections that are present in a criminal case. Thank you.
Good afternoon, Chair Barker, members of the committee. Becky Strauss here on behalf of the ACLU of Oregon. I too have submitted written testimony, and so I'm just going to highlight that and also echo the comments from OCDLA. I just want to at first take a moment to acknowledge that the many people who did come here today in support of this bill, and particularly those who have told their story publicly, I recognize that that takes a lot of courage and really appreciate that. And this bill and these cases present some very compelling arguments, and we certainly respect that. There are some real victims who have suffered some very real harm by these crimes, and why I am here, why the ACLU is here in opposition to the bill, is really to raise the compelling reasons to maintain a statute of limitations. And Gail touched on a lot of those, so I won't go into too much detail, but I think there's an important protection here for the defendant, and particularly the defendant who is innocent. And those are the interests that we're here to protect. The statute of limitations provides very important safeguards, as I mentioned. And really, it's about being able to present a case before the evidence goes stale. The prosecution, within a few years of the crime, allows the defendant to confront the accuser, allows the defendant to call witnesses, prepare a defense. But as time elapses between the crime and the trial, it does become increasingly difficult to do that in an effective way, if not impossible, for the defendant to prepare a meaningful defense. And that's why we have a statute of limitations, and why we think it's important to protect that even in these instances. So we very much appreciate the intent behind this bill, and certainly acknowledge the highly sensitive nature of the issues, and urge you not to move forward with the bill. Thank you.
Any questions? Thank you very much. We're not prepared to move the bill today, and so I'm going to close the public hearing on it.